the Roman Empire fell. Basically, when we really go down history, everyone thinks about barbarians, marauding was, that's not what happened at all. The Roman people simply stopped believing that the Roman government was anything other than a corrupt mess, inefficient, incompetent, unable to meet their needs. That one of which included keeping barbarians out. But there were others. That's our concern.
Hey, everybody. Welcome back to the California Dream podcast. I'm your host, Darren Brown. And today I have a really important interview to share with everyone. Really important. Recently, I sat down to talk with Hannah Miyamoto. Now, Hannah has been an activist in California independence for some time, but I brought her onto the show specifically in response to a current event. Last week, I talked about the Supreme Court ruling related to the Alabama gerrymandering of congressional districts. This is a ruling that I think all of us should find concerning, but the reasons why it should concern us go well beyond the particulars of the case. There are much deeper concerns that this ruling and other rulings raise. And while I can intuitively sense these deeper concerns, I don't really have the legal background or the expertise to address those aspects with any authority. And that's really why I invited Hannah onto the show. She is a retired attorney and brings a wealth of knowledge about the law, philosophy of law, legal institutions, the federal courts and the Supreme Court, and international law. And we explored some issues that we both think all Californians need to think about. The interview runs almost an hour and a half, so I broke it into two parts. In this first half of the interview, we discussed this Alabama gerrymandering ruling in detail and what it means for confidence in the federal court system. In the second half of the interview, which I'll be releasing next week, we discussed the recent abortion law passed in Texas, the SCOTUS ruling on that law, and the implications of how that went down. And I'll be frank, these are difficult discussions to have. It's neither easy nor particularly comfortable to talk about these things. But we must talk about them. Because what we don't want to do is close our eyes, put our fingers in our ears, and just pretend that none of this is happening. We can't live in denial. We have to deal with reality and live in the real world, no matter how uncomfortable or unsettling that might be. Our guest today is a retired attorney and holds a JD degree from Hamline University School of Law. She's also the executive producer at Pacifica Studios. Please welcome Hannah Miyamoto.
Hello, everybody. First, to let you know, it's Pacifico Studios. I don't want Pacifica is, of course, have no connection to the Pacifica Network and a few other things. That's okay, no problem. That's just saying. Just want to make that clear. I use the Spanish language pronunciation of that word, Pacifico.
Right. That is because of Amy Goodman. I think that I just.
Oh yeah. I'm no Amy Goodman. I'm a lot more conservative than Amy Goodman, and I will claim. But maybe in some ways I'm more radical. So we're going to talk about Merrill versus Milligan.
Yes, and before we get started with that particular case, if you could very briefly, because a lot of our audience is actually outside the United States, so they might not be familiar with how things are structured here. what is the structure and function of the federal court system and the Supreme Court, and how specifically does it relate to the other two branches of the federal government as well as to the state courts and governments? I know that's a big question,
That's a very
but
big
just
question, and I will try to not talk too fast. And as I try to say this, explain this as clearly and as briefly as possible. If we go way back, on the United States Constitution, we have three branches of the federal government. We have an executive, which is headed by the President of the United States. We have a legislature, which is composed of two houses, the Congress and the U.S. Senate, or House of Representatives and U.S. Senate. And also we have the judiciary. Now, what distinguishes the judiciary, that's the judicial system or the federal courts. What distinguishes the judiciary from the other branches is they're not allowed to make laws. Their purpose is to interpret the laws and, of course, determine whether a law is within the Constitution. Either the state is it within the United States Constitution? They also, so state laws, whether they violate the federal Constitution, but basically, lawyers or judges like to talk about the knight errant. The Don Quixote, the knight on the horseback who charges around looking for injustice and evil in the world and correct it all by themselves. This is not what federal judges do. They are not, as they say, knight errants out to fix the world from their bench. What has to happen instead is people bring what the Constitution of the United States calls cases and controversies to the federal courts. And they also have to have jurisdiction within either original jurisdiction of the United States under the U.S. Constitution, which doesn't really apply to most individuals, or United States federal law that provides jurisdiction. In other words, for instance, if Darren, you happen to have a copyright, say for this podcast, and somebody else were to steal your podcast, you would then have a right under federal law because your copyright is protected by federal law. And the federal law allows you to go to federal court to uphold your copyright. Although, frankly, there's a little bit more steps than that. But nevertheless, that's an example of just one of many examples. Don't counterfeit money. That's be a federal offense. Things like that. Okay. Now, maybe we should talk about federal court system. We'll start with the United States Supreme Court, 9 members, everybody in the Article 3 courts. I think only Article 1 courts are immigration courts, bankruptcy courts, things like that. But in the Article 3 court system, which is what everyone thinks of when they say the federal courts, they're all lifetime appointees. That's number one. And the President of the United States appoints them all. The United States Senate confirms them by majority vote. That's the so-called advise and consent. By the way, I should point out that I don't think there's anything in the U.S. Constitution that requires the Supreme Court and the Senate to actually agree. I think the president can appoint federal judges as they want. It just says advise and consent. It doesn't say requirement. But over several hundred years of history, the rule has become that the Supreme Court the Senate can prevent the president from appointing a federal judge. Back to our world. So I'm not going to go much longer. The Supreme Court is the top, 9 members. They're all appointed, blah, 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 by the usual process. Below them are 11 Circuit Court of Appeals, each one applying to a particular geographical area of the country. California is in the 9th Circuit Court of Appeals. It happens to be the physically largest one, especially if you went by total surface area, because it includes the state of Hawaii. It definitely includes the West Coast states. And it includes a lot else. Alaska, Hawaii, all the Pacific Islands are all in the 9th Circuit, and of course, California and the West Coast states, and I think Nevada, whatever, doesn't matter. 9th Circuit. Just say briefly that there are many judges in the circuit courts, even at the 9th Circuit. But normally what happens is when you have your case in the Ninth Circuit Court of Appeals, you get three judges, a panel, we call it, to hear your case. And then if you don't like that decision, you have the right to appeal to what's called the en banc, in which the entire court hears the case. Okay. Then below them, you have the district courts. And that's probably what you're going to see most likely when you go downtown in your city to look at the federal courts. Like, for instance, San Diego, where I live next to, has a district court, a U.S. district court. And if you want to turn on your TV, say somebody's getting arrested for drug trafficking, that's a real common federal offense, you'll see the lawyer standing in front of the district court. Again, same kind of rule applies. You bring your court case up, you get one judge. Here's your case. One more thing about the district court is they serve as the fact-finding body. Everyone's heard that phrase, you get your day in court. Well, in the federal court system, it's several days, but we call it a trial, in which you present your evidence and somebody else presents their evidence, and there's a whole very complicated procedure. But the idea is you present the facts of the case and the legal arguments you're going to make. And once you've come out of the district court system, as a general rule, you're not going to be allowed to present more evidence once that district court has, closed the trial. Even if you did, for whatever reason, the miracle witness is suddenly released by the Taliban and is now available for deposition, you would go to the Ninth Circuit Court of Appeals, and then they would remand the case. We call it remand the case back to the district court, and you have a new trial or a partial trial, a partial hearing, or whatever, to present that evidence. So this is all very important for this Merrill case, by the way, because that's one of my criticisms of the U.S. Supreme Court decision. I think they ignored the normal procedure in the federal court system, and everyone suspects that it's because of political reasons and not because they believe in the fair administration of the law or the orderly administration of the federal laws.
So just to summarize, we have the states and we have state law and state courts, and then there's the federal system, which is the overall within the federal government, but it has very restricted powers, or it's supposed to have restricted powers in the sense that it is only supposed to intervene when there's a federal issue at stake, and it's only meant to interpret the law, not to be making law, just to see if a judgment is comporting with the Constitution and with the law.
Well, there's also well, you mentioned what you talked about earlier was federal question jurisdiction. A federal right is being being infringed or something like that, and there's also diversity. So you'll see a lot of product liability cases wind up because you have more than $50,000 of controversy and blah blah blah. That's diversity. Most states, that used to be the old rule where you had to go to federal court. Now that's a long time before, like 1936. Since 1936, states have generally made it possible. So, if say, if you need to sue somebody in another state, I mean, say a business deal would be a good example of that. You got a business deal going on with somebody in Arizona. You think they did you dirty. You could sue them in California court, and they'd have to come from Arizona to defend themselves. Why? Because by making the contract in California, they availed themselves. That's what we like to say. They basically made it. Of course, that's why other laws, like we all know, choice of venue. There's all kinds of there's also contract provisions. But if you just simply made a deal and you don't have any other paper, involved in your decision, in your case, in your situation, that your contract, then if you make a deal with someone in another state, you can expect to be sued in their state.
So, what is this term that's called shadow docket? I know it's a relatively recent term coined, I think 5 or 6 years ago.
Shadow docket. I was thinking to myself, have we had another name for it, which was per curiam? this United States Supreme Court has always issued what they call per curiam decisions. A per curiam decision means, well, it literally means in law for the court, and it is generally unanimous, but it doesn't have to be. But generally, it's been unanimous, and the Supreme Court has reversed lower courts without an opinion. In other words, say both parties bring their brief, that's your argument, you know, and terrible injustice has been done, your honors. No, it hasn't been done. They read them, and then they say, we give this judgment to you're right. This court screwed, really, really did you dirty, and so we've reversed. And they don't have to write an opinion. It saves time, obviously. But you could just imagine that's probably when it's overwhelmingly one way. You just have a court that's almost out of control. Shadow docket on the so per curiam, because it says for the court, that literally means nobody writes the opinion. It is just we, the U.S. Supreme Court, hereby rule. And then other judges can issue their dissent. Usually they issue a concurrence, which says something like, I just want to know that this is my understanding of the decision, or something like that. But many times there's nothing at all. It's simply the decision. I could write one right now. It would be, decision of the Ninth Circuit Court of Appeals heard below is hereby reversed. Per curiam. Done. Okay. And there you go. And now shadow docket is quite a bit different, because what makes it different is because it's clearly contested cases. Yeah, Merrill versus Milligan, decided February 7, 2022. It doesn't say per curiam at the top of it. See? This is not a per curiam decision. It doesn't say so at the top. In fact, this one has all kinds of people's names on it. It begins, the first opinion, it's interestingly enough, it mentions that it was appealed to Justice Thomas. I probably should have mentioned that. It's Kavanaugh, with whom Alito joins, writes a concurrence, which is really unusual, because this case it says right there that the case was referred to Thomas. So why is Thomas not saying anything? And why doesn't Thomas concur? Then we have Roberts in dissent. He's Chief Justice. Then we have Kagan with Breyer and Sotomayor joining, and they're in dissent. So that tells us this was a 5-4 decision. And so it was a contested case, narrowly contested. You can't get more contested than this. And it's just the 5 Republican-appointed justices who, agreed to it. Although it's curious, because you only have the word of Kavanaugh and Alito. So where's the other 3 people's opinions? And why didn't they write anything? Why didn't they even concur? It's as they say in the movies, it's spooky. I'd understand if all 5 of them were to concur to Kavanaugh's opinion, then that'd be fine. But why aren't they on here? It's very weird. It's almost, I don't know. Again, there's a lot of mysteries. The first mystery is why did the plaintiffs agree to have the course to not object to the case being appealed to the U.S. Supreme Court by the state of Alabama. Then there's the fact that, and then we have the fact of that about the justices. Now, when you first read the concurring opinion, it says basically, look, the district court in Alabama issued their decision on the January 24. January 24, they issued their decision, saying that gerrymandered maps, the apportionment of Alabama could not go used for the primary. Okay, maybe we should back up a bit, just so everyone understands. So we had a maybe we should, again, for the benefit of our foreign, people not familiar with the legal system, with the American political system. So I'll be brief. In our system, uh, it's commonly thought that we only have two parties. In fact, we have many parties, but we have an electoral system in which, for practical purposes, only members of two parties have a chance to win, and they're the Republican Party, the Democratic Party. In theory, we have a lot of other parties that could win, but they just tend not to get more than a few percentage of the vote. And anybody can run for office in these states, and they seek the nomination of the party, right? But when you think about it, there might be, let's say, 3, 4, 9, whatever numbers of people who want to run for office under a particular platform, I mean, under a particular party. I'm a Democrat. If I would run, I would be running. If I ran for office, I'd be running to get the Democratic nomination. It's a little bit like in a parliamentary system, where you go to your local parliamentary district committee and you try to become the named candidate for your party in that particular uh, parliamentary district. I believe it is in they're called districts, aren't they? In United Kingdom, I think so.
I'm not sure.
Yeah. Okay, then we're both unsure. Anyways, you get the point. So what we have instead in the United States is we have a primary election system, and the winner of that primary election for every particular party, typically the major parties, obviously the smaller parties. If you're running as a libertarian or something, you probably there probably has nobody running against you. But if you're running as a Democrat or Republican, chances are there will be someone running against you. Members of your local people who have identified themselves as being members of that party. I'm registered as a Democrat, for instance. I can only vote in Democratic primary elections. Uh, won't go into all the details beyond that. But the key is that whoever wins, one person from each party, and then they go to the general election on the ballot. That's the basic system. That's in a nutshell. That's what's going on now. In particular, the state of Alabama, they have, of course, a long history of racial issues. They've had slavery for over almost 200 years. They were members of the Confederacy. And as pointed out by the Kagan dissent, there even as recently as last year, uh, the last election, you've had uh, political nominated candidates making direct appeals on the basis of race. Congressman Mo Brooks repeatedly claimed that Democrats were, quote, waging a war on whites. And Roy Moore, another Republican, asserted that the civil rights amendments of the Constitution, which includes the 14th Amendment, that, for that matter, includes the 13th Amendment that bans slavery, that the 14th Amendment that requires equal protection of the laws, and the 15th Amendment that's supposed to guarantee voting rights. He said that completely tried to wreck the form of government that our forefathers intended. So we now know that Roy Moore is apparently a supporter of the slavery, the enslavement of African American people.
So just to be clear, when they're saying that this is like a violation of the Voting Rights Act, one of the conditions you have to show is something like this, that this is a candidate who is explicitly advocating like a white supremacist ethnic nationalist state.
Yeah, it's a very complicated case, and I don't want to get too much into it. But the point is that Alabama made a very interesting argument. Interesting probably is the wrong word. Now, first thing, Alabama, the state of Alabama happens to be 27% black. 27% of the people identify as African American. I'm going to do some quick math here.
7 congressional districts.
Right, and that's how they got the 1 out of 7, isn't it? Yeah, that's how they got the 1 out of 7. Yeah, 27%, and they basically the Republican legislature uh, drew a boundary in which only basically all the African Americans were piled into one one district, and so you know uh, as a result, uh, a fair racially neutral map should have put it, presumably African Americans should have been able to vote, have a good chance of influencing the election in two districts, not just one district. That's the argument to be made. But Alabama made an interesting argument. They claimed that the plaintiffs had to be racially neutral in drawing a map, which in a way is showing no guidance whatsoever. I mean, I will say right now, I think the decision should be that in cases like this, it should be the burden on the state. I think the burden should shift, and I think the burden should shift to say, okay, if you want to really complain, then you show that there's some logical reason why you managed to put all the black people in one district and deny them a second district.
And this was a part of the Voting Rights Act that was actually struck down previously by the Supreme Court, right? There was this pre-clearance requirement.
Yeah, I mean, right, but they still allow pre-clearance, but now they're allowing you to go to sue after the decision, the apportionment's been made.
Right.
But another point we might make is, remember I'd said that the district court in Alabama ruled in favor of the plaintiffs on January 24? Well, the thing was, there was a lot of testimony in this case. They held basically a full trial. They heard it from everybody. All kinds of experts looked at all kinds of maps. Justice Kagan, I believe, said that there were 1,000 pages in the record. So a very busy court reporter. Lots of computer models, and they point out that you've got computer software that's able to do all these maps really quickly, and on and on and on. So there's no, and one thing, and the majority of the Supreme Court never argued that the district court did not do a good job. They never argued that this was a slapdash thing, or there was a rush to judgment, or anything like that. And as I said, it's going to be difficult. But it's very difficult to go through this frankly, for non-lawyers to understand. I would contend that in a case like this, there is a strong interest in obviating, I would say is the right word, dispelling the idea that there is racial bias in our electoral system. This is the argument I've made a lot. And I think the Supreme Court has really messed this up. That if there's any job that federal courts should be doing, it is giving people a strong reason to believe in their government and their constitution and the laws. Because after all, we know from history that when a large number of people feel that the laws are not being fairly enforced, disorder results. Right? As the Bible says, where the leaders have no vision, the people will surely perish. And I think that's what we're really missing here. It's not about putting down the good people the good legislators of Alabama. It's not saying that they're bad people or they're white racists or anything like that. It's not, but it's saying let's not allow the impression to be made that there is Jim Crow being revived in Alabama. I think that should be the rule. That's just me, but you could tell me if you think that's a reasonable approach to this, and maybe another reason why the Supreme Court kind of really missed the boat here.
Well, I'm not a lawyer. First of all, just get that disclaimer out of the way. But I did read the decision. I'll just say to start off, I thought Kagan's writing is really strong writing. I mean, it was really eloquent, especially towards the end of the decision. But my overall impression is that this appears as a politically motivated decision, that they would like to have an advantage in the 2022 midterms. And this decision is basically allowing the Republicans to maintain a congressional district that they would lose otherwise. Since they don't want to lose that district, they just decided that the outcome has to determine how we decide it, and so they just took this chance to get that outcome. That's how it appeal. That's how it appears to me as just a non-lawyer from the outside.
I just wanted to say that the phrase we actually use in the law is outcome determinative. And the nightmare, speaking speaking for most lawyers, would agree with me on this. The nightmare is that the population or lawyers believe that judges go on the basis of, who do I want to win? Okay, I want that person to win. Now I'm going to write my decision based on, to make it look like I want, make it like it's logical why I should write for why that side should win. That's not what's supposed to happen. And I'm going, before there was the United States of America, English judges were arguing, were insisting, and English legal experts, the Blackstones and the Liveys, I mean the Blackstones and the Cooks, they were arguing that no, the judge finds the law, or the judge hears both sides, follows the law. That's what we like to say. Judges follow the law. This is how you get decisions that may be unpopular to many people, but they are the law. The classic case I always could bring up to is like, a lot of people don't think that you should have the right to burn the American flag. And they'll make all kinds of arguments they like. But if you read the cases of the U.S. Supreme Court, it's still your legal right to burn your American flag. Assuming, if you do it, maybe the only thing you could possibly say is, you probably wouldn't want to be allowed to do it in a gas station or someplace where they don't allow flames. But if you can do it safely without endangering others, go ahead, light them up. So is that a popular decision? No. Should most people not burn the American flag? I would say, yes, that's correct. They shouldn't burn the American flag. But you have the right under the U.S. Constitution, because that's a fundamental law of the United States of America. So there you go. That's an example of how it is. So back to it. Outcome determinative is the phrase that you're trying to reach, and that's literally what you just stumbled on it yourself. It's the outcome, and we don't want that. Oh, and there's one more thing I like to point out at this point too, that I think Kavanaugh. I don't think any of the judges actually pointed this out, but I think there's a much bigger issue, and that's the belief that conservatives can take virtually any case in the world and bring it to the U.S. Supreme Court. Like, no matter what happens at the lower court level, that the whole system is stacked in their favor because of politics. I think that's a real worrisome thing, because obviously there goes the legitimacy of not just the Supreme Court of the United States, but the entire federal government. And let's not forget, why did the Soviet Union collapse in 1989, 1991? Very simple. The people of the Soviet Union stopped believing in the Soviet Union. They stopped believing that government was representing their interests or had their interests at heart, and off it went. Now that may be an extreme case, but that is many countries have fallen, many governments have fallen over the thousands of years, and oftentimes the Roman Empire fell. Basically, when we really go down history, everyone thinks about barbarians, marauding was, that's not what happened at all. The Roman people simply stopped believing that the Roman government was anything other than a corrupt mess, inefficient, incompetent, unable to meet their needs. One of which included keeping barbarians out. But there were others. That's our concern. I should say one more thing though. I'm going to raise the issue of Lochner versus New York. That's a 1905 case, and every lawyer knows about that case. And in plain English, what Lochner versus New York did was the U.S. Supreme Court decided that it could declare unconstitutional basic laws, business regulations, and wage and hours regulations. When I was a kid, in the state of Minnesota, where I grew up, if you bought a pound of margarine, it had a 10-cent sticker on it. And the reason was it was a little like a cigarette sticker, like a cigarette tax sticker. It was like a little tax like that. It was the same idea. It said that a 10-cent per pound tax had been paid to the state of Minnesota on that here box of margarine because it was yellow. Because in Minnesota, white margarine was untaxed, but yellow margarine, which looked like butter, was taxed. Now, why was that? That means to be a crazy law, but that's not the point. The point is, the United States Supreme Court, back in the 1920s, I think, had ruled that law was constitutional. Because when they first passed that law about the state tax on colored margarine, it was challenged, and the thing was, it was challenged as a regulation, as an unconstitutional law. There was a concept called substantive due process, 14th Amendment. But the point was, any law that involved business regulation. I remember a Supreme Court case that involves how you could cut whether or not a particular state could regulate the how much weight in a bread loaf. Okay? Or could you sell movie theater tickets outside the movie theater? And there were just ridiculous numbers of these cases. And of course, another one was, could a state prevent a father from sending his child out to work in the local furniture factory? U.S. Supreme Court said no in 1922. They said no, that was depriving the father of the right to of the income that their child could generate as a worker.
Wow.
You get my point here? Yeah, that's where we come from. But the real point I'm making is, in that situation, you could be a reformer, go off and say something like, I think it's wrong that children are allowed to should be allowed to be working in factories, and I think they should be at school, or something. And you'd go and you and your buddies would work really hard, and you'd get a law passed, and the businesses would say, we're going to take this to court. And they would lose at the district court level, and then they'd appeal, and they'd lose at the Circuit Court of Appeals level. And then they'd say, but we haven't really lost because we're going to take it to the U.S. Supreme Court, and they don't like these kind of laws. And then it's a 50-50 shot. But like I said, it went back and forth. You couldn't predict it. That's what I'm trying to really get at. The real problem here is a system in which no decision is considered really permanent until the U.S. Supreme Court hears the case means that you can't predict the outcomes of these cases, and lawyers just hate it when they can't predict what a court's going to decide a case. You come to them and you say, here's my case, and they say it's a 50-50 shot. You want, because after all, let's you've just had the decision about how whether or not the loaves of bread can be more than can be a pound or a pound and a half. I mean, you come along with your movie theater ticket. How do you judge? How do you apply that decision to this other one, right? And that's what happened. So in 1936, was Supreme Court of the United States uh, said no. Basically, they got out of that business. They basically said, uh, first thing they said, state regulations on businesses and labor are presumptively valid. Number one. Number two, uh, don't take these cases up to us. And there's a real classic case, Williamson versus Optical. It involved opticians in Oklahoma, and 1953. Now we're after the Second World War, but they tried that again, and they just flipped it away, and they said, look, the state of Oklahoma decided that this was a good law for opticians to follow, and don't ask us. What do we look like experts about opticians?
So I think what you're getting at is that one of the harmful effects of what's happening is that you should be able to tell how cases are going to proceed based on general principles and not based on the specifics or particulars of a case, and that's starting to erode.
Yeah, it's already eroded, especially given the fact that so many people. You know what this reminds me of is when I practiced law. Private lawyers like myself felt that federal lawyers on the other side, the U.S. Attorney's Office, their attitude was, we don't have to really brief our cases. We don't have to do anything because we're going to win at the Supreme Court. I mean, that'd be the idea that they thought that that the Rehnquist court was so pro-federal government that, well, it doesn't matter what happens below. And worst of all, it leads to sloppy lawyering. I mean, if you believe that, well, the court's just biased in my favor, then, it just invites this kind of sloppy work. Because after all, they're biased. They're just going to decide just when you're in your favor. Why do you have to work at all? You go through the motions. That's what, at least that was the suspicion. Now we've got a more now there's a difference though, right? Because it's one thing to have a court that's biased for the federal government. It's quite another to have a court that's biased for a particular political party or a political agenda.
So that was the first half of my interview with Hannah. Stay tuned for next week when we talk about the Texas abortion case and what it might mean for a potential route for California independence.